We will have a full agenda today, probably expect to work till noon, and open the hearing on Senate Bill 462, prohibiting certain public nuisance claims, requiring the Attorney General to bring nuisance actions that are not wholly contained in one political subdivision, requiring special injury for certain public nuisance actions, and providing an accrual period for the statute of limitations in public nuisance actions. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 462 creates a new section of law. Section 1 there creates a non-exclusive list of actions or conditions that shall not be considered a public nuisance or form the basis of a public nuisance cause of action. I'll let you read through those. Subsection B provides that in a public nuisance claim, the plaintiff shall have the burden of proving by a preponderance of the evidence that the defendant's actions were both the cause in fact and the proximate cause of the alleged public nuisance. When determining cause in fact, the court shall find that the defendant's actions the cause and fact of the harm if the alleged public nuisance would not otherwise exist in the plaintiff's jurisdiction, or the plaintiff's expenditures to abate or address the nuisance would decrease by more than 25%. When determining proximate cause, the court shall find the defendant's actions the proximate cause of the harm if the defendant engaged in the activity that directly caused the public nuisance and the public nuisance was a reasonably foreseeable result of the defendant's conduct, or the defendant controlled or instructed one or more third persons to engage in the activity that directly caused the public nuisance and the resulting public nuisance was a reasonably foreseeable result. Subsection C provides that a public nuisance action may be brought by a political subdivision only if the alleged public nuisance is wholly contained within the jurisdiction of that political subdivision. If not, then the Attorney General is the only governmental official or agency who may file a claim regarding the public nuisance. Prior to filing that claim, the Attorney General would be required to consult with and obtain the written approval of the governor. In a public nuisance action filed by a political subdivision or the Attorney General, the court shall not award monetary damages of any kind or the cost of abating potential future public nuisances. A public nuisance claim may be brought by a private person only if that person has sustained a special injury, which is defined in the bill. Such private person shall have the burden to prove by clear and convincing evidence that the defendant's actions were the cause in fact and the proximate cause of the special injury. The court may only award damages in these cases in the form of compensatory damages for the special injury that are not otherwise reimbursed by a governmental entity. Abatement of a public nuisance by a defendant does not preclude the right of a private person to recover damages. A private person shall not bring a class action for a public nuisance claim. This section would apply to claims that are pending or filed on or after July 1st of 2026. If a pending claim may only be brought by the Attorney General, then the Attorney General shall be substituted as plaintiff and shall request that the case be dismissed unless the Attorney General obtains written approval from the governor. Subsection F provides definitions that are used in the section, and subsection G provides a severability clause. Section 2 amends KSA 6513. This is the civil statute of limitations for claims that shall be brought within 2 years. This section is amended to provide that a cause of action for public nuisance that involves continuing or recurring conditions shall be deemed to have accrued at the time the plaintiff first discovered or should have discovered the condition, and the identity of the defendant and subsequent reoccurrences shall not start that period of limitation over. And I can take any questions.
Thank you. Committee, any questions? Not seeing any. Then thank you very much for the brief. For our conferees for the hearing, I do see we have a couple on to speak in total. We do have 2 other bill hearings we're trying to get through today as well, so we're going to have to be mindful of time and going to limit testimony to 3 minutes per conferee. However, we will have additional time for questions. And we will have questions on the bill probably at the end of all the testimonies, so we can hopefully move along. Our first proponent conferee is O.H. Skinner, Executive Director, Alliance for Consumers Action Fund. Please introduce yourself and welcome to committee. And if you're unfamiliar, the manila envelope means 1 minute remaining, so please try to wrap up. Thank you.
Great, thank you so much. Madam Chair, my name is O.H. Skinner. You have before you my written testimony. I will try not to redo any of that. As I wrote in there, I spent nearly 5 years in the Arizona Attorney General's office working on consumer protection cases and arguing before the U.S. Supreme Court for that office. And then over 5 years ago, I set out to start Alliance for Consumers. What I do in my time is I try to provide a lost voice for consumers. I argue for more payouts from cases, whether they're private or public, to actually go into the pockets of everyday consumers. I speak about regulations and rules, whether it comes from Washington, D.C. or elsewhere, that end up making consumers' lives worse. I spent a lot of time in the last presidential administration talking about dishwashers and cars and air conditioners and everyday things that were getting worse in people's houses. Our top concern now is lawfare. And what we really mean by that is courts being used to control and impose a lifestyle and an ideology on people, no matter where they live and no matter what choices they want to make for their families. What you'll notice is that consumers don't like it. They don't like when courts are being used to control their lives. And we've done some polling, 90% of consumers believe that legal actions are being used to advance political purposes. 74% oppose lawsuits to impose political agendas. 85% are worried about legal actions being things that press ideological beliefs and responses onto people. Public nuisance is the poster child for that situation. It is a primary tool that is being used by activists across the country to go after cars, to go after plastic straws, to go after guns and firearms. And there's a lot of talk about farmers, cows, utilities. Anything in this disfavored category amongst activists on the left is a target on public nuisance is their favorite tool. That's bad for consumers and bad for the options that consumers have at the store for their family. Worse, it doesn't put any money into consumers' pockets. The dirty little secret about public nuisance claims is that no money flows to anybody who suffered from the nuisance in question. It's just supposed to be money that fixes or removes the nuisance and often ends up flowing into government and NGO coffers, not into actual consumers' pockets. So we view nuisance as being something that has a limited value to solve a unique set of problems, and I'm happy to talk to anybody about that. 462 is a practical reform from what we're reading. It sharply limits the ideological uses of public nuisance. It would retain key limited uses that would allow it to solve problems, and it would benefit consumers, democracy, and the rule of law. So I will end by saying that we think 462 confirms how policy should be made, and that we don't need to be having it happen in the courtroom, and with consumers' lives being governed by lawsuit instead of by the legislative process. And with that, I'm happy to take any questions or yield back anytime.
Thank you. Sure, we'll go ahead and hear from any other proponent conferees wishing to testify on the bill. Not seeing any, then we're going to go ahead and have opponents and neutral, and then we'll open it up for questions. So with that then, opponent conferee Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. Please introduce yourself and welcome to committee. Okay, we'll consider that written testimony then. And next, Nathan Eberlein, Executive Director, League of Kansas Municipalities. Please introduce yourself and welcome to committee.
Good morning, everybody. My name is Nathan Eberlein with the League of Kansas Municipalities. Thank you for your time here today. Our cities understand the concern about expansive litigation and the regulation through the courts. We share the legislature's interest in predictability and appropriate limits on liability. But SB 462 undermines the responsibility of municipalities by centralizing authority, limiting local remedies, and shifting costs onto residents. SB 462 is drafted broadly enough that it doesn't just limit large multi-state litigation, it also constrains local routine nuisance enforcement. Some of these examples would include former manufacturing buildings, salvage yards, illegal dumping sites. These are not abstract policy disputes. These are real places that cities deal with on a regular basis. Cities step in because somebody has to. SB 462 makes it harder to recover these costs and harder to act quickly when problems exist. Under the current law, when a property owner or an operator creates a public nuisance, Cities can seek abatement and recover the costs. SB 462 narrows that authority and eliminates monetary recovery in many circumstances. Practically speaking, that means that cleanup, remediation, and enforcement costs don't disappear, they just move to local taxpayers. This bill requires statewide nuisance actions to flow through the Attorney General with governor approval. That makes sense for large policy cases, but it creates real delays for local problems that need quick resolution. Cities are closest to the issue. They see the conditions, they hear from neighbors, they respond first. This bill replaces that local judgment with a centralized gatekeeping authority. Kansas cities are not trying to regulate through the courts. We're trying to keep neighborhoods safe, recover taxpayer costs when the harm occurs, and resolve these problems at the level of government closest to the people that are affected by the problems. 462 moves in the opposite direction by centralizing authority, limiting the local remedies, and shifting costs onto residents. For these reasons, we respectfully ask this committee to consider the real municipal effects and not advance this bill in its current form. Thank you.
Thank you. Next, we will hear from Michael Koss, City Attorney, City of Overland Park. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. I'm Michael Koss. I am the City Attorney for the City of Overland Park. I appreciate the committee's giving me an opportunity to present my testimony opposing this legislation. We oppose it because it makes it essentially impossible for cities to pursue public nuisance claims. It will make it harder for the state to pursue nuisance claims, and that will result in Kansans not receiving the benefits from these types of lawsuits. So there's been two major lawsuits involving public nuisance claims in the last 25 years. That's the tobacco litigation that settled in 1998 and the opioid litigation that settled in 2021. The most recent, the opioid litigation, the city was involved in along with dozens of other municipalities across the state and thousands of municipalities across the country. This resulted in Kansas receiving $340 million in settlement funds that are now being used across the state to fight the opioid epidemic. It has been an amazing success. The overdoses from opioids across the country have plummeted significantly since that settlement occurred, and from 2023 to 2024 alone dropped by 35%. The aggregate pressure of those thousands of municipalities being part of that litigation helped the plaintiffs leverage to secure that settlement that has been such a success. And that could not have happened if this bill had been law. It says that municipalities could not participate in that litigation if it's not wholly contained within the municipality's jurisdiction. Well, we did have costs for law enforcement, our EMS folks giving Naxalone to people who were overdosing, but that was not limited to Overland Park. Those were problems for cities across the country, and so municipalities couldn't have participated. And it also limits the cause of actions that the state can pursue, puts a cap on, not a cap, but limits damages, just makes it harder for the state to bring claims to. So in closing, I hope there's no lawsuits in the future like tobacco litigation and opioid litigation because that harmed Kansans, but I'm afraid there will be. And if there is, I don't think you're going to want to have limited yourself so that Kansans can't benefit from those settlements like they have from those two lawsuits. And with that, I'm happy to stand for questions at the appropriate time. Thank you.
Thank you. Are there any other persons wishing to testify as opponents on the bill? Not seeing any, then committee, you do have opponent written testimony from David Dillner, City Manager, City of El Dorado. And then we will hear from neutral conferee Chris Kobach, Attorney General, Office of the Attorney General. Please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman and members of the committee. It's great to be in front of you for the first time this session. I'm Chris Kobach, as was just mentioned. So we are testifying neutrally on this bill, Senate Bill 462. This bill does address a very significant nationwide problem, one that is actually manifest in Kansas in 2 different cases. But in its current form, we cannot support the bill. We have a series of balloon amendments that we've handed out to the committee. If those amendments are made, we would support this bill. To just give you a quick snapshot of how this problem manifests in Kansas, Ford County, Kansas has basically been recruited by some plaintiffs' attorneys to go after the oil industry. They brought one case in federal district court in Kansas where they are arguing that the oil industry has contributed to the production of plastic bottles, and plastic bottles are not as recyclable as claimed, so the lawsuit alleges, and so therefore the oil industry must pay fantastic damages. In federal district court in New Mexico, Ford County, Kansas, is going after the oil industry with respect to shale oil production. Now, it might be necessary, hypothetically, for some states to go after an industry like that if there truly were a nationwide problem caused by that industry. But that's where the Attorney General possesses the authority of parens patriae, which is a legal doctrine that if there is a problem suffered by all of the people of the state and perhaps by other states, the Attorney General steps forward. And that's why you see some blue states right now suing President Trump, making allegations of that nature. And during the prior administration, you saw states such as Kansas stepping forward. Some of those are public nuisance cases. Some of those are arguing that a regulation is violation of federal law. But let me get to the point here. We've seen it in Kansas, where public nuisance theory is abused by a county in a case of this nature. So what about the suggested edits or suggested amendments? The first one would preserve the Attorney
Would it
General's...
be helpful to have those passed out?
Yeah, go
They're
ahead if
written
you
down,
want to
so-
have them passed out. I'll just go through them quickly. One is to make clear that the Attorney General, as Kansas statute already provides, controls litigation for the state of Kansas, including whether to bring a suit or not to bring a suit. Kansas statute already includes that, so this bill, as proposed, would contradict existing Kansas statute. You need to have one voice for the state deciding whether there is a public nuisance and a public need for a litigation of this sort. You can hold that individual, the Attorney General, accountable. You can vote him out at the election if you think he is not correctly assessing the position that Kansas should take in litigation. The second change has to do with municipal authority to bring public nuisance claims. Here, I think the bill needs to be strengthened, and in particular, it should be removed. Now, we just heard from opponents saying how important public nuisance doctrine is for municipalities, and they gave the example of the opioid litigation. The municipalities did not win extra damages from the opioid manufacturers. It was a carve-out. The states brought the case, but then a bunch of municipalities came in too, brought parallel litigation. It was all negotiated with the assumption that the municipalities would get a chunk of the settlement. If the municipalities had not brought their redundant litigation, the same money would have flowed out to the state of Kansas. So it was entirely unnecessary. The other problem with municipal public nuisance authority is that Overland Park might take this position. Dodge City might take that position. You have 2 different municipalities assessing the public good of the state of Kansas or the people of Kansas. It's inconsistent, and again, it's redundant. The Attorney General can exercise that authority. Third change is that there's a broad carve-out that would prevent the use of public nuisance doctrine in circumstances like the opioids case, where you have downstream uses of a product. That's what was essentially happening with opioids. We would remove that language in Section 1A2. And then finally, there's a broad prohibition in the bill of basically all monetary relief, and that's in Section 1C3. Our amendment would keep that monetary relief in Kansas law. If you don't have the possibility of damages, then your litigation doesn't really have any effect or any desired effect driving a settlement, and that's usually what you look for here. So with those 4 changes, we would be amenable and we would be supportive of Senate Bill 462. Thank you.
Thank you. Appreciate you coming over today and visiting with your testimony. Thank you. Is there anyone else wishing to testify as neutral on the bill? Not seeing any. Senator Clays, I don't think wants to testify as neutral, but probably wants to start us off with questions. So go ahead, Senator Clays.
Thank you, Madam Chair, and this is directed to the Attorney General, and looking at, in particular at that Ford County case, it appears that that you move to dismiss that case, but also preserve the state's right to bring its own action if you felt like the situation warranted it. Wouldn't SB 462, by requiring you to get the governor's written approval before filing that kind of claim, doesn't that hinder your ability to exactly that in the Ford County case? Looking at the anyway, I just find it very odd, I guess, that you need the written approval of the governor as opposed to, say, maybe just checking in with maybe the legislature, which is a different political body, and having them maybe check off on it as opposed to governor. Thank you.
I agree. It is very odd. Nowhere else in Kansas law does statute or the Constitution require the Attorney General to get written approval of the governor. We are a state where the Attorney General is elected separately. The idea is that the Attorney General might be a check on the governor, regardless of whether the governor is Republican or Democrat, whether the Attorney General is Republican or Democrat. The governor might be tempted to do something that is contrary to federal law or state law, and the Attorney General can weigh in and say, no, you shouldn't do that. Or alternatively, the governor may not want the state to take action where the Attorney General sees that there's clear legal cause to take action. And so, yeah, that's why we have separately elected offices. So this provision is one that needs to be stricken. I think this is a model bill that, in some states where the governor appoints the Attorney General, that might be appropriate, but it would not be appropriate for Kansas. Also, given that we have Kansas statute that says the Attorney General, it's passed in 2013, I believe, says the Attorney General controls all litigation for the state.
Thank you. Committee, other questions? Senator Titus.
Thank you, Madam Chair. I'd start with Attorney General Kobach. He'd come back up. I appreciate your testimony here, but it seems like you're focusing on making this bill a lot like a bill we heard last year on class actions or some with the municipal ability to bring litigation. This bill is really about codifying common law nuisance claims. And it seems like you want to make it something else. Am I misunderstanding that?
I wouldn't say that this bill codifies common law nuisance claims, although you're right, it does add some definition. It has to. If it's going to ban them, it has to define what nuisance claims are. But you are absolutely right. Both bills address two different aspects of the problem. One aspect is the actual claim itself, which has been abused. The whole concept of public nuisance has been abused in the last few decades. But then the other point is the actual mechanics of the Ford County case. And it's not just Ford County, Kansas. There's Baltimore, Maryland, a number of jurisdictions in California. But where plaintiffs' attorneys go in and say to a county, hey, we'll bring this nationwide case and you're going to make huge buckets of money if we prevail. Can we use the name of your county as a plaintiff? And that's essentially what happened in Ford County. By the way, in Ford County, I was there not too long ago and asked a number of the city leaders in Dodge City and county leaders, including the county attorney, were you aware of this litigation? No one was aware. As far as I can tell, the only record of it is there's a meeting where 2 of the 3 county commissioners were present. A decision was made to proceed with litigation. No debate. I don't know how it happened, but nobody in Ford County seems to even be aware that their county name is being used, I would say hijacked or commandeered to bring litigation. So hiring contingency fee plaintiff's counsel to bring these cases on the part of municipalities is a problem as well. But ideally, this bill as amended would also address another problem, which is the misuse of public nuisance doctrine.
We talk about the Ford County case as an example, but
yeah.
I always like to point out, the city of Mulberry, we had 2 attorney generals that couldn't put together a price gouging case, and the little city of Mulberry ends up protecting themselves because the state wasn't able to do it. And I worry by passing something this broad, there are things that the state won't be involved enough in or decide to take up because of all of the balances you have to deal with statewide. This seems like the perfect example of where local control really can benefit our taxpayers.
Well, I don't have the Mulberry case you're referring to in front of me, but I would be surprised if that were a public nuisance claim. That would almost certainly be a specific tort claim or other type of claim. So we've looked just for the past 25 years to see if any city or county has used public nuisance claims successfully to address a specific concern of that city or county and successfully done so. We can find none in the last 25 years. I think the nature of cities and counties has changed over the past century. Now we have ordinance books that are very long and very detailed, and you have codes that are, with respect to the zoning of various parts of the city that are very specific and very detailed. And so public nuisance isn't really necessary for cities to address specific problems. They can use ordinances and they can use other forms of litigation and even criminal penalties in some cases. Thank you.
Thank you. I have a follow-up question. We heard from the opponents that the bill takes away the ability of the city, any city, to pursue nuisance claims. And I do see in the bill, however, in section 1C, it does provide that a public nuisance may be brought by a political subdivision if the alleged nuisance is wholly contained within the jurisdiction of such political subdivision. And I think striking that portion of the bill is one of the amendments that you propose.
Yes.
So that I'm not sure that the opponents were accurate when they say that the bill totally takes away the right to pursue a nuisance claim on behalf of a city, but the proposed amendment that you have would, and it would only allow the Attorney General to bring that. So could you speak to that a little bit? You touched on it a little bit.
Yeah, I did touch on it a little bit, Madam Chair. And the point is that a public nuisance claim by its very nature is a broad harm suffered by the public. And so most public nuisance claims can't really address the specific things that a city might need anyway. That's why I pointed out in the last 25 years, there's never been a public nuisance case addressed to a city-specific problem. When the cities did join in the opioid litigation, that was completely redundant. The states, and Republican and Democrat states acting together, had already achieved what was going to be, the damages that would be recovered through settlement, and the cities were simply given a carve-out because of their redundant additional litigation. So my point is that cities don't need public nuisance, and when there are specific things that are happening in a city, there's something that is causing a harm that is city-specific or county-specific, you can use ordinances, you can use, in some cases, criminal law. There are so many other tools that the modern city has available. That's why you don't see an example of cities using public nuisance doctrine for specific problems anymore in Kansas.
Thank you. Committee, any other questions for the conferees? Senator Clays.
Thank you, Madam Chair, and thank you, Mr. Attorney General. So I'm sure you're aware of this, but we have 10 states that are using public nuisance theory to go after firearms manufacturers and expose firearm manufacturers to liability and criminal, they would call criminal misuse of their products. Do you feel like, after we, or if we were to pass these amendments, do you feel like SB 462 is written in such a way that those kinds of public nuisance issues would never be used as a vehicle for that kind of strategy in our state?
It certainly would be impossible for plaintiffs to recruit a county or a city and use that city as a platform to bring litigation against a firearms manufacturer. The bill would certainly address that problem. And there was a case in Kansas where there was an attempt to go after Beretta. And this case recently went to the Kansas Supreme Court. They didn't use public nuisance theory in that particular case. They tried to make a claim that the product was defective because it didn't have certain devices they wanted to have on the product. And the court rejected that claim because there's a federal statute that protects commerce in firearms, and that statute was seen to prohibit the claim that was brought. But there are constantly plaintiffs and individuals and entities and organizations out there that are trying to sue the firearms industry. Public nuisance doctrine in the hands of a city or a small county like Ford that could be persuaded to hand over the county name as a platform for litigation is an active threat.
Well, we'll need to keep it short. Thank you.
And very, very sweet. So I guess when I look at that particular case, I believe it was actually upheld by the Second Circuit, though, and I know that you're talking about the protection of lawful commerce in Arms Act is probably what you're talking about, but it appears that the Second Circuit in just July of last year upheld using public nuisance. What are your thoughts on that? And again, do you feel like SB 462 is going to shield us from that?
So the case I was referring to was a case brought in Kansas State Court. Second Circuit would be a case brought in federal court on the East Coast. And absolutely, public nuisance doctrine is used by some plaintiffs as their claim to bring similar litigation against firearms manufacturers with the same objective to either stop a particular firearm from being manufactured or impose significant restrictions upon it. So yeah, there is absolutely throughout the country in all of the thousands of courts where you could bring this case, plenty of opportunities to use public nuisance doctrine, and that's, again, I think why the proponents of this bill brought it forward. In Kansas, in that Beretta case, they didn't use public nuisance, but they certainly could have tried and probably would try if they wanted to get a second bite at the apple, or some similar plaintiff wanted to get a second bite at the apple.
Thank you. And Senator Corson.
Thank you, Madam Chair. My question's either for the opponents or proponents or for the neutral. I'm not sure that I would agree with the characterization of the Ford County case, but being that what it may, I do worry that this legislation really prohibits cities from standing up for the best interest of their residents. It really disarms what could be in certain instances, probably very limited instances, because there are, as you pointed out, other ways to enforce it, ordinance, other things. But I do think that this is taken away from cities, a really critical tool for acting in what that city, in their view, under local control, believes is the best interest of those residents. You could have a situation where a city could feel like they're very much harmed, and the Attorney General just says because they may not have bandwidth, they may not have staff capacity, they may just ideologically not want to pursue the litigation, that there's no ability for a city to move that litigation forward if the Attorney General, or the way the bill currently is without the amendment, even if the Attorney General wants to do it and the governor doesn't want to do it. So I just think this is really best left to cities to make those decisions themselves. And I don't think we've seen real evidence in Kansas that this has really been abused in any meaningful way. I would just really dispute that characterization.
I would simply respond, and I'll keep it brief, that Ford County is a perfect example of abusing it. They are using public nuisance doctrine to speak not only on behalf of all residents of Kansas, they're actually trying to speak on behalf of all residents of the United States and say—
Right, they're using public nuisance doctrine in a way that you personally or your office may disagree with. That doesn't mean that they are abusing it. It means that they're using it in a different way than you think it should be properly used. I think that's an important distinction. That's your personal view that it's being abused.
Let me clarify. I'm not saying they're abusing it because they're taking a particular stand against the oil industry. What I'm saying is they are attempting to use the legal doctrine of parens patriae, which is the parent of the state, and say, we speak for the benefit of the state. The problem with that is Ford County may say, we don't like what the oil companies are doing. Johnson County may say, we do like what the oil companies are doing. And so if you have counties attempting to speak for the benefit of the state in court, then you have conflicting opinions. Better to have one elected official take that position or not take that position and then be knocked out in the next election if the people of Kansas say that Attorney General wasn't speaking for the people of Kansas.
Thank you. Appreciate that.
I'll let others, unless you want to follow up.
We're gonna
Real quick.
Quick
But I mean, in
follow-up.
that example, I mean, Ford County really would be left without any recourse. If the Attorney General decided that they didn't want to pursue it under your hypothetical, Ford County would be out of luck. Maybe citizens would have to wait 4 years to elect a different Attorney General, but Ford County would be completely without recourse under that example if the Attorney General, either for ideological or just office capacity reasons, decided that they didn't want to pursue it.
But the residents of Ford County are not suffering from the alleged non-recyclability of plastic bottles any more than the residents of Boston, Massachusetts are. It's not like that leaves them without recourse for a specific problem they're addressing. The public nuisance doctrine is not necessary to address specific problems in the various counties.
Thank you. Appreciate the testimony today and the questions. We want to make sure we maintain decorum and respect for our conferees and for our committee members as well. With that, then, we will close the hearing on Senate Bill 462 and open the hearing on Senate Bill 463, prohibiting certain persons from recovering damages in certain civil actions and creating requirements for actions involving negligent security. With that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 463 creates a new provision of law. Subsection A creates a new section saying that a person who engaged or participated in wrongful conduct or attempted to do so shall not bring an action for negligence or collect damages for negligent conduct related to that wrongful conduct. The party against whom the negligence is alleged shall have the burden of proving by a preponderance of the evidence that a person was engaging or participating or attempting to engage in wrongful conduct. Subsection B provides that general damages, including damages for wages, shall not be awarded in an action for negligence arising from an automobile accident to a person who was an unauthorized alien at the time of the accident. A party who wishes to file such a claim shall provide documents showing that at the time of the accident, the person was a citizen or a lawful permanent resident and not an unauthorized alien, which is defined in the definition section. This subsection shall not apply to a claim made against an uninsured or underinsured motorist policy that names the unauthorized alien as the insured. Subsection C provides that in an action for negligent security, an owner or occupier has no duty to protect an invitee or licensee from any type of wrongful conduct of a third person unless that owner or occupier has actual knowledge of previous occurrences of substantially similar wrongful conduct on the premises within the immediately preceding year. If the owner or occupier does have that knowledge, they shall have a duty to take responsible care under the circumstances. There shall be a presumption that such duty was met if the owner or occupier either requests the assistance of law enforcement and followed their instructions, followed the guidelines of a reputable party related to security and safety measures, or hired a security contractor. An owner or occupier has no duty to protect an invitee or licensee from their own wrongful conduct or the wrongful conduct of a third person if the invitee or licensee is on the premises for the purpose of or in the course of engaging in wrongful conduct. A person who's committing criminal trespass or a person on the premises outside of posted business hours shall not maintain an action for negligent security. If an owner or occupier has engaged a security contractor, that contractor shall have the same duties to the owner or occupier or as the owner and occupier under this section. If the trier of fact does find a party is liable in an action for negligent security, then the trier of fact has to make an apportionment of fault and be instructed to apportion fault among the party that brought the claim, the owner or occupier, any governmental agency or unit of government that failed to enforce law or maintain order, any third person whose wrongful conduct or negligence contributed to the event giving rise to the cause of action, and any other person deemed necessary. And they have to make that apportionment regardless of whether damages would be able to be collected from that person. If the trier of fact fails to make that apportionment, the court shall set aside the verdict and order a retrial of both the liability and the damages. There shall be a presumption that an apportionment of fault is unreasonable if the total percentage of fault apportioned to persons who engaged in wrongful conduct is less than the total percentage of fault apportioned to the other persons. Such apportionment shall be subject to appeal de novo in that case. Nothing in this section shall prevent a victim of crime from receiving restitution, and the section would apply to claims that are pending or filed on and after July 1st of 2026. Subsection F provides the definitions for relevant terms used, and subsection G provides a severability clause. And I can take any questions.
Thank you. Any questions? Not seeing any. Thank you. Appreciate it. Committee, we'll still stick for our conferees, please, 3 minutes, and we'll hear from proponent O.H. Skinner, Executive Director, Alliance for Consumers Action Fund. Please introduce yourself and welcome to committee again.
Thank you, Madam Chair. I'm O.H. Skinner. I work at the Alliance for Consumers Action Fund. You already have my written testimony on this bill as well, and you just heard my career and life story here. I speak about protecting consumer freedom, and an under-addressed part of that is crime. I think that's something that more and more people need to talk about. Crime is a consumer issue, and that is why I support SB 463. At base, consumers need some simple things. They need open stores. They need goods on the shelves of those stores. They need to have trust in the shopkeepers and store owners, and they need safe streets. Almost everything that I do in my career focuses on those topics, whether it's holding businesses accountable for deception, whether it's talking about crime, they're all focused on these things. Crime, especially unchecked crime, defeats almost everything I just identified. If you've ever been to San Francisco and seen what unchecked crime looks like, it looks like stores that are empty. It looks like things being sold on street corners. It looks like parents who can't find baby formula or medicine for their children that has not been manipulated, stolen, and taken and stored in a back lot, okay? That is not acceptable. And letting criminals and others profit off of their crime through lawsuits does a double badness for consumers. It foments more of it. SB 463 is a common sense bill. We've done some polling. 92% of Kansans in our poll believe that criminals who are hurt in the process of committing a crime shouldn't be able to sue a property owner, whether that's a homeowner, a business owner, somebody who's renting an apartment, okay? 6% of the people in Kansas who are polled think that that makes sense, which explains to you how common sense this should be. This bill tackles criminals and negatives that are happening from the consumer perspective, and it reflects a very simple principle. Criminals, wrongdoers, people who are here illegally or unlawfully, they cannot sue in negligence and turn crime and wrongdoing into a profit center for themselves and their friends and allies. And that is really why we urge you to step up for consumers and pass something that is to us incredibly common sense.
Thank you, and committee will wait for questions till we hear from all the conferees. Is there any other person wishing to testify on Senate Bill 463 as a proponent? Not seeing any. Then we will hear from opponent conferee Richard Budden for Matthew Birch, Schamberg, Johnson, and Bergman. Please introduce yourself and welcome to committee.
Thank you, Chair. I am Richard Budden. David Morantz is actually, he's going to address the first two parts of the bill, so if you don't mind, he's also testifying for KTLA. If he could go first, then I'll go after him. Would that work for you?
Oh, sure. So we will then invite David Morantz on behalf of the Kansas Trial Lawyers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. David Morantz on behalf of the Kansas Trial Lawyers Association. Good to see many of you. I've been testifying here for about 15 years on various bills, and I've got to say this is one of the more interesting bills I've seen. I'm really not sure what current problems in Kansas it's trying to address, but it certainly doesn't address longstanding Kansas law, including our own Bill of Rights. We got to start with the very broad definition of wrongful conduct that's in Section A, and that's much broader than what we have currently in our comparative fault scheme. That's 6258A. You probably don't want to know that, but the import is that's been Kansas law for 50 years. This body passed a comparative fault scheme more than 5 decades ago that addresses the types of issues that you heard about. If a plaintiff tries to bring a claim for being injured while being a porch pirate, which no plaintiff's attorney is going to take, that plaintiff will get kicked out and won't have a claim if he or she is found to be 50% at fault or more. So our law already addresses this supposed problem. But the very broad definition of wrongful conduct would go well beyond the crimes that you just heard about. Let's say that I forgot to put my teenage son's updated tag on his license plate on his vehicle. And let's say he was killed by a drunk driver while he's driving. Well, he was driving with expired tags. Under the definition of wrongful conduct, that would be included. My son and my family would not be able to recover in that situation. Our comparative fault scheme accounts for that well, because the wrongful conduct has to play a role, it has to play a causal role in the incident. Here, the wrongful conduct only has to be related to the claim of negligence. Driving with expired tags would have been related to the collision. Another example, this body has done a lot of work the last couple of years protecting teenage sex abuse victims. Many of those victims receive alcohol or other illegal substances from their abusers. If they consume that alcohol, or if they even possess it, or THC, for example, they're a minor in possession of a controlled substance. They have conducted wrongful conduct. They would be forbidden from recovering under this bill. Another example, let's say there's a college bar that's notorious for bar fights and for underage drinking. Let's say they let an underage kid in. They don't even card him. They give him alcohol. That kid's injured when a brawl gets out of control. That kid couldn't recover, even though the bar didn't card him, even though his drinking had nothing to do with the outcome. Another issue I want to point you all to is the effect this would have on subrogation and liens. And this is a boring subject under the law, but subrogation and liens are how insurance companies recover when their insureds are hurt. It's how Medicaid, Medicare recovers. It's how the Kansas Crime Victims Compensation Fund recovers when they pay a victim who's for restitution for a crime. Similarly, those folks step into the shoes of the people who are injured. And similarly, if a driver like my son received compensation from the Kansas Crime Victims Compensation Fund, the compensation fund couldn't come back later and try to recoup those payments because they would step into his shoes. This would upend the workers' compensation system, and I direct you to the written testimony from Phil Slape and John Vogelai that explains the importance of subrogation claims and how that keeps our workers' compensation system solvent and affordable. Finally, I'll turn to Section B.
We're out of time, so we're going to have to ask you to wrap up so we can get to everyone today.
In Section B, this flat out contradicts Section 18 of our Bill of Rights. The Kansas Bill of Rights.
Doesn't sound like wrapping up, but
it states all persons
your
have a
time
right
is
to
up,
redress.
so are you going to wrap up?
Yes, persons is broader than just aliens or citizens. It includes everyone. So this bill has some major constitutional problems. Thank you, and I'm happy to stand for questions at the appropriate time.
Thank you. Appreciate that. Next, we will hear from Richard Budden for Matthew Birch, Schamberg, Johnson, and Bergman. Please introduce yourself and welcome to committee.
Thank you. I'm Richard Budden. I work at Schamberg, Johnson, and Bergman. I'm here for the Kansas Trial Lawyers. Thank you for your time. I want to discuss subsection C of this bill, which purports to change the standards that apply to tort claims alleging negligent security. I say purports because the plain language of subsection C seems limited to negligent security claims, but the definition section of the bill says something completely different. So subsection F1 defines claims for negligent security as any claim against an owner or occupier or security contractor that sounds in tort or nuisance, arising from an alleged failure to make or keep the premises and approaches safe and seeks to recover any damages. What that means, this is not just negligent security, this is all premises liability claims. That's what that definition means. So just keep in mind, every time it says negligent security in section C, it actually means all premises liability claims by definition. By design, subsection C1 changes the duty owed by the owner or occupier of a premises. Under current law, landowners owe their invitees, somebody they bring onto their property, a business customer, a client, the landowner or occupier owes that invitee a duty to protect them from unreasonable hazards that the landowner either knows of or reasonably should know of based on the circumstances. This is a good rule because it means that landowners have to be proactive. They can't bury their heads in the sand about a potential hazard on their premises. If a premises owner should be aware of a safety hazard on their property that could hurt someone that they have invited onto the premises, they must fix or warn the invitee of it. The change this law would make is that when the safety hazard involves the wrongful conduct of a third party, the premises owner now would only owe a duty to invitees to eliminate that hazard if they know that it has actually caused someone harm within the last year. Now, problem number one, this creates something like a one-bite rule for premises owners. One-bite rule being, in the context of a dog bite case, some states have a rule that the dog owner is not liable for a dog injuring anyone until they have bitten one person before. So they get one bite free. And here, this bill is saying a business owner who should maybe reasonably know of a problem with safety on their premises gets the same benefit of the one-bite rule. They don't have to act unless and until someone is actually injured. Then they have a duty to act. But before then, they don't. I don't think we should institute a one-bite rule for all premises liability cases. Giving them one free bite doesn't make a lot of sense. Problem number two, this doesn't just allow a premises owner to bury their head in the sand about a foreseeable safety hazard. It actually encourages them to do so. Any defense attorney worth their salt will advise clients that this new Kansas law allows them to avoid liability for safety hazards they should know about if there is no evidence they actually knew about such hazards. So now the monkey with his hands over his eyes, seeing no evil, becomes the model business owner in Kansas. That is bad policy. Should the owner of a dive bar be allowed to sit on their hands until someone gets shot or stabbed before they institute reasonable security measures? No. I'm going to give you one more hypothetical. I like to call this the Epstein
Well,
Hotel
we really need to
scenario.
wrap up. Your 3 minutes is over. So
Absolutely.
do you have a
Thank you.
concluding statement?
Yeah, just one more last scenario to think about. So how about a
Well, this
hotel
is a
owner?
new hypothetical, so why don't we wrap up with a concluding statement, or we'll just end your 3 minutes because they're over.
Sure. If a hotel owner knows that.
This is the hypothetical, so
It's
do
the
you want?
wrap-up hypothetical, Your Honor.
Well, we'll see.
Absolutely. I can wrap up. Summarize, subsection C of this bill creates a niche category of specific rules that apply in premises liability cases alone, creating bad incentives for owners to ignore potential hazards unless and until someone gets hurt, no matter how foreseeable. I encourage this committee to reject this proposed bill for those reasons. Thank you.
Thank you. Is there any other person wishing to testify as opponent on the bill? Not seeing any, then we do have opponent written testimony from Philip Slape and Howard, Logan DeMond, Director of Policy and Research, ACLU of Kansas, and Tess Sanford Ramirez, Co-Director of Protecting Kansas Children from Sexual Predators. And we will open it up for questions. You get one bite at the apple, though, with your questions, so since we're running out of time. So do we have any questions? Senator Shane.
Thank you, Madam Chair. If we could get the proponent to come up, Mr. Skinner. To make sure I want to make sure I understand kind of at least the motive behind the bill. I believe the motive is somebody breaks into my store, breaks their leg, and tries to sue me because they broke their leg while robbing my store. I believe is the intent of this. I'd like you to address that and then follow that with any response to the hypotheticals that were put forward by the opposition. Thank you.
Thank you. If you just reintroduce yourself. Thank you.
Sorry, O.H. Skinner from Alliance for Consumers Action Fund. The exact purpose of the bill is what you described. I would say it does cover one step further, which is if somebody hops the wall behind your house and is about to break into your house and slips and falls, that's also covered because wrongful conduct includes these intentional torts. And so you don't want somebody who's about to porch pirate and slips say, well, I didn't actually steal anything yet. Right, so that's the exact purpose of the bill. And I would note that we're very happy with what we see here, which is it says in the definition section under wrongful conduct that it needs to be a violation that constitutes a crime. And so these scenarios of you didn't put a sticker on this, you didn't do that, you didn't tie your shoelaces right, it's not going to be something that will end up constituting a crime. And then the last hypothetical that I'll flag is anybody here who's ever had the misfortune of involving themselves in the legal system where they're not getting paid by the hour or they're not getting paid a contingency knows that if somebody is a porch pirate, they slip on your front porch and they sue you and you get served with that lawsuit, it's very cold comfort that down the road, after you've hired a lawyer and gone to court, you might be able to prove that they were more than 50% liable. So in this narrow circumstance where somebody's in the process of doing something that we can all agree is wrong, that 90+% of Kansans that we've polled think is wrong, we want those people to not have to get that lawsuit in the front door. Because we don't want this to be a back-end fix where you, the homeowner, or you, is going to have to hire a lawyer and pay for all of that to then prevail on what, to everybody else on the street, they think is gobsmackingly obvious to them. So if you have any other questions, I'm happy to answer them, but I think those are the most important things to understand.
Thank you. Senator Corson.
Thank you, Madam Chair. This question is also for the proponent. So I'm just really searching to find a Kansas connection to this bill. Crime in Kansas is at a 20-year low, which is a great thing, and I think that's in part to a lot of good work done by this committee, that we are at a 20-year low in crime. So I mean, we heard about like empty grocery store shelves in San Francisco and like some other stuff, but I'm just not really haven't heard much that makes me think that this is an issue that the Kansas legislature needs to address. I'm just not aware of claims where robbers trying to break into homes are suing homeowners, and those cases are being litigated in Kansas courts, or cases where people are breaking into businesses and then suing in Kansas courts, and that's been this big problem that we need to address here in the legislature. So just kind of help me out with that piece, kind of bring this back to Kansas for me, and how this can help improve our state here.
One of the things that I think is important to understand is not everything gets the high-profile news coverage. What the media cares about is not always what everyday people care about. And I would say that if any number of people are being hit with these lawsuits, that's too many. And I feel like when you have something that's this common sense, that you talk to your average person on the street and they say, how is that not already the law? I think that protecting your state from something like this is a very important thing to do, and that you shouldn't have to wait until your entire yard is on fire before you decide to get the hose. And this one feels to us like a very common sense pro-consumer thing that keeps your state from looking like something like California, keeps your state from being a place like San Francisco, because nobody wants to wait until these problems really explode into full force before thinking about whether they could have stopped it with something that is a very 90% common sense type of an issue.
So the entire yard would be on fire. Can you name me one example in Kansas? Can you just give me one example?
We don't have a long list of examples from Kansas, and in large part that's because, as I just flagged, if somebody were to threaten somebody with a lawsuit like this, your average homeowner, your average small business owner, we've seen this in many other states with other types of claims. If somebody threatens you with a lawsuit and says you're going to be liable, but I'll settle it for $5,000, it doesn't end up making the news. And so rather than look around for news stories and news examples, we think it's really important to take action now.
Okay, well, I wasn't even looking for a long list. I was just looking for one. But so I think I've sort of made the point, Madam Chair. I'll wrap up.
I think it's important, no matter how many times this has happened, that this not be something that happens to a single Kansan. I think that's I think that's reflected in the 90% numbers of support here.
So thank you. I appreciate that. I just want to say, I mean, I think, you know, lawyers, I think, have a sometimes well-deserved reputation for wanting to make money. And I think that there's an incentive among attorneys to try to bring meritorious cases. And so I'm just not convinced that any of the Kansas attorneys I've ever met or have worked with, either as co-counsel or opposing counsel, or that I'm aware of in Kansas, would really be wanting to bring cases of this nature. Because again, I don't think that Kansas juries would be really sympathetic to that. And so I don't think that I just think the pure business dynamics of it really have done a good job of weeding out all of these cases.
Thank you. We do have a question from Senator Clays, then Senator Haley, and we're going to have to move on.
Yes, thank you, Madam Chair. And since hypotheticals are so popular today, I want to give you one real quick. If you were a rancher, do you think it would be a good idea to close the gate before the cows got out? Thank you.
As my grandfather owned a bunch of cows, and so notwithstanding my trust in cow guards, yes. Yes, I think that you don't need to trust all the cattle guards. You need to close the gate.
Thank you, Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Skinner, for being here. I'm just wondering where your organization is based. Are you Arizona-based?
The organization, I live in Phoenix, Arizona. It's where I've spent most of my career. I have very small children that really like to run around in the backyard in January and February, so that's a feature. Alliance for Consumers Action Fund is based in Tennessee. That ended up being an easier place for us to incorporate, just like a company might incorporate in Delaware.
Welcome to Kansas, Mr. Skinner. And how many other states are you pursuing similar legislation to? Well, not only this one, 463, but 462. Is your organization looking at different states as well? I imagine Kansas isn't the only fortunate one to consider.
Kansas is the first state that we've ever proposed a bill in. First time I've ever testified in the legislature, so thank you for your being so generous to us. But I would love to see this be passed across the country. I think this is exactly the kind of common sense thing that people think legislatures do, and it's the kind of thing that when you talk to people on the street, they already think is the law.
Well, finally, and thank you, Madam Chair. Mr. Skinner, why are we the lucky ones? How do we draw the short straw or long straw, Kansas, to be the primary experiment for these considerations?
There's a million accents to how things happen, between your legislative session being one of the fastest ones that I've ever seen, and the fact that I've heard great things about your state, and you seem to have a high level of collegiality. I mean, you guys are some of the fastest actors I've ever seen. So, if I were talking to you in a year, perhaps it would be that we were in a different spot.
Thank you, sir. I appreciate that, and thank you, Madam Chair.
Well, thank you for the discussion, the testimony from the conferees. And with that, then, we will close the hearing on Senate Bill 463. And we're going to try to get through the hearing on Senate Bill 375, enacting the Proxy Advisor Transparency Act, requiring proxy advisors to make certain disclosures when recommending an action against company management, authorizing the Attorney General to investigate and take enforcement actions against violators, and establishing a private right of action for declaratory judgment or injunctive relief. With that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 375 creates some new provisions of law. Section 1 names the act. Section 2 provides that the legislature makes particular findings with respect to proxy advisors. I won't go through all those, but you can read them. Section 3 provides for definitions of terms that are used throughout the act, most notably the definition of proxy advisor and the services they provide. So I would recommend that you read through those. Section 4 provides that if a proxy advisor makes a recommendation against company management, or a company or proxy proposal, or makes a default recommendation or policy involving votes against such proposal, and such proxy advisor does not make that recommendation based on a written financial analysis, the proxy advisor has certain duties. They have to, concurrently with providing the proxy advisor service, include a clear and conspicuous disclosure to each shareholder that identifies the service being provided, identifies the recommendation or policy at issue, and states that the proxy advisor has made that recommendation without basing that recommendation on a written financial analysis. They also have to provide, concurrently with the proxy advisor service, defined in subsection F1 or F2 of section 3, the disclosure that's required under subsection A to the board of directors of each company. That's the subject of the proxy advisor service. And also, while the proxy advisor services are being provided, they have to publicly and conspicuously disclose that the service includes one or more services that include recommendations or policy against company management that are not based on a written financial analysis regarding the impact of those recommendations. If a proxy advisor does make a written financial analysis, then the advisor has to, again, concurrently providing with that service, include a clear and conspicuous disclosure to the shareholders that identifies the services being provided, the policy recommendation at issue, and that the proxy advisor has made the recommendation or policy based on a written financial analysis that analyzes the expected financial benefits and costs to the company, concludes what vote or action is most likely to positively affect the shareholder value, and explains the methods and processes used to prepare that written analysis. And it also has to state that the analysis is available on request. They also have to make that analysis available within a reasonable time to any client or proxy advisory service on request, and provide concurrently with the service the same disclosures to the board of directors of each company. Section 5 provides that a violation of this act is a deceptive and unconscionable act or practice under the Kansas Consumer Protection Act. The Attorney General may investigate if the Attorney General has reason to believe that a violation has or will occur. The person committing the conduct prohibited by the act shall be deemed the supplier and the victim deemed the consumer. In addition to the enforcement under the Consumer Protection Act, a person aggrieved may bring an action seeking declaratory judgment or injunctive relief. Not later than 7 days after the action is brought, the plaintiff would be required to provide written notice to the Attorney General, who shall have the right to intervene. An aggrieved party includes a recipient of proxy advisor services, a company that's the subject of proxy advisory services as defined in subsection F1 or F2 of section 3, or any shareholder of a company described in subsection C2. And section 6 provides a severability clause. And I can take any questions.
Thank you. Are there any questions for the reviser? Seeing none, we'll move to proponent testimony. Mr. Dumey, if you would step forward and introduce yourself to the committee.
Thank you, Madam Chair, members of the committee. My name is Matthew Dumey. I work with Fusion Law on behalf of Consumers Defense. And you already have my written testimony. So what I want to do with my 3 minutes is focus on 3 points that I've seen in the written testimony submitted by the 3 opponents of this bill, as I think that'll be more helpful to the committee. The first point is who the bill covers. All 3 of the opponents note that the bill could cover a nonprofit. The bill specifically says a proxy advisor provides advice for compensation. So if you're paying for advice this bill ensures that you get disclosure on whether that advice is based on a written financial analysis. Now, in the case of Green America, they apparently do this for free. They just provide advice as a nonprofit. That's fine. They wouldn't be covered. In the case of United Church Funds, one of the other opponents, they are compensated, and in fact, they have $1.2 billion in assets under management. They need to tell their clients the truth. The second general topic is what the bill requires. For example, the Taxpayer Protection Alliance, another opponent, says that nonprofits would struggle to produce a written financial analysis for their clients. They don't have to under the bill. Under the bill, you only have to disclose whether or not your recommendation is based on a written financial analysis. That's important information. And if it is based on a written financial analysis, then you can make that available. Similarly, Green America says that the bill requires proxy advisors to give a financial analysis or say that they're not working in the financial interest. That is not true. If you look at the bill, I think Green America's misunderstanding is based on a Texas bill that was passed last year, and it was preliminarily enjoined. The court had concern about the fact that the Texas bill specifically said certain things were non-financial factors, and that if you were making a recommendation based on those factors, then the proxy advisor had to say that was non-financial. This bill takes a totally different approach to solve the same problem. It specifically just focuses on written financial analysis, which is objective, that's purely factual, the terms are defined, and so as a result, this is a nonpartisan bill. Just last month, I was testifying in Indiana, and the bill passed out of committee unanimously, even though it was bipartisan. And finally, United Church Funds also says there are extensive disclosure requirements. They aren't extensive. You simply have to say whether or not your advice is based on a written financial analysis. The last point I have is that the Taxpayer Protection Alliance says it's suspect that this is limited to recommendations against management. But this isn't suspect at all. Management is subject to fiduciary duties. They are making recommendations based on a written financial analysis. So if you are going to say, no, management's wrong, then the person that you're giving the recommendation to, they should know whether your advice is also based on a written financial analysis. And I would also note that it's inconsistent that Taxpayer Protection Alliance is saying the disclosure is too burdensome, and then also suggesting it should be applied to more situations. So those are the arguments against the bill. I think if you examine the bill closely and look at my written testimony, you'll see those arguments are inaccurate and they're not based on what the bill actually does. This is a common sense consumer protection measure that would help people in Kansas. Thank you.
Thank you. Are there any other proponent conferees wishing to testify? Not seeing any, then we'll invite opponent conferee Noah Tabers, United Church Funds on WebEx. Please introduce yourself and welcome to committee.
Thank you, Chair. Is my technology working okay?
We can hear and see you, yes.
Wonderful. Thank you, Chair Warren, members of the committee. My name is Noah Tabor. I'm the General Counsel for United Church Funds. UCF is the investment partner for United Church of Christ. UCC's got about 30 churches or so across this Kansas area. In a prior life, I was in Topeka as an insurance lobbyist, and I had the full Kansas experience. I got some wisdom from Jim Denning. I think Senator Longbine almost had me in a Chevy up in Emporia. And of course, I got my rear end kicked by the Farm Bureau. So I think, Ad Astra and all that, I had a good time in Topeka a number of years. Thanks to Grace for being virtual today. Again, UCF's been doing this for about 100 years. We are active owners. We engage our companies on things that are missionally important for us. This is not transactional work for us. This is ministry work. But the way this bill is written and the definitions that are in page 3, line 3 and line 6, proxy advisor services, captures the work I do. And UCF votes our proxies, and a big issue, I think, for the committee, recommendations company management on a executive compensation, something my churches care deeply about. If we were to write a blog or newsletter post talking about how we, UCF, voted our proxies on that executive compensation, is that research? Is that analysis? We're awfully worried it might be. Again, I don't think the intent of this bill is to get faith-based investors like UCF, and many denominations do the work that we do as well. I understand the intent of this bill might be at the Glass Lewis's and the ISS's of the world. Again, these broad definitions capture the work we do, which is, again, not transactional. it's ministerial. And I appreciate the proponent name checking us, and actually it's 1.4 billion assets under management. And we are quite worried about this work, and it is onerous in this disclosure regime. We are a little nonprofit of 12 souls, and disclosure regime around this would be incredibly chilling for our work. So again, committee, I look forward to being in Topeka next week to talk with you in person, explain more about our work as mission, as ministry. But again, the way this bill is written, the definition is so broad, it would get the things that we do at our stewardship, not proxy advisor services. We encourage the committee to not advance the bill in its current form. There are other states who are looking at this. I think
1 minute remaining.
Thank you, Chair. The proponent name-checked Indiana, who, yes, Indiana is looking at this bill, and they're considering carving out nonprofits to, again, let this bill go to the effective places it's intended to, the proxy advisors, and let us faith-based investors who have been doing this since the first publicly traded company, the East India Trading Company, moons ago, had faith-based investors. We've been doing this work a long time. It's stewardship, it's ministry. Madam Chair, thank you for the time and the grace to be virtual today. Happy to answer questions when appropriate.
Thank you. Next, we will hear from Kathy Becker, Responsible Finance Campaign Director, Green America. Please introduce yourself and welcome to committee.
All right, thank you so much. Can you hear me okay?
Yes, we can hear and see you.
Okay, great. So thank you so much for the opportunity to testify regarding Senate Bill 375. My name is Kathy Becker. I'm the Responsible Finance Campaign Director at Green America. Founded in 1982, Green America is a national nonprofit that helps consumers and investors harness economic power to create a more just and sustainable world. So we oppose Senate Bill 375 on two major grounds. First, we feel this bill is biased since it singles out only recommendations that go against company management and does not apply evenly to all proxy recommendations. A similar bill in Texas was found unconstitutional for this reason. And second, it could unreasonably interfere with our ability to provide information to our members and supporters. So regarding the first objection, it requires proxy advisors to supply a written financial analysis only if the recommendations go against company management. So as far as I know, company management, if they are recommending to vote against a certain shareholder resolution or for it, they don't provide a whole, they do have fiduciary duties, but they don't provide a whole analysis based on that particular recommendation, which the proxy advisor would have to do. And in Texas, the similar bill that was mentioned, SB 2337, a federal judge put an injunction on that. Because of this, the plaintiffs had argued that it forced them to adopt a state scripted message that contradicts their own professional judgment and that it singles out speech based on content. So this was a First Amendment argument, and the judge did agree with that. And I believe the Attorney General there in Texas has decided not to pursue appealing that. The other issue in the lawsuit was vagueness of definition of, we have the same concerns, like as what we post on our website for our members and supporters that's available for anyone to see if they go look, is that research and analysis. And there isn't a specific, we would like to have a specific carve out for nonprofits in here because this bill is actually a little bit broader than the Texas bill, which only applied to Texas companies. This bill would allow anybody who receives this advice, which could be anybody that comes to our website, if they counted that as advice, or just research and analysis. Anyone who receives this research and analysis could bring a civil action.
1 minute remaining.
And our second objection, okay, that flows into what we do. So we provide information to our members and supporters. It's basically consumer education about banking, credit cards, insurance, investing, and shareholder advocacy. We explain what shareholder resolutions are, how people with stock can vote on them. A lot of individual investors don't. We're very different from a Glass Lewis or an ISS. They charge for their services. We don't. They're for profit. We're nonprofit. They provide personalized recommendations, which we do not. We don't provide financial advice. We provide information and education, and it's up to people to decide how that applies to them. And they work mainly for institutions. We work mainly for individuals. So we do ask that you will consider these constitutional concerns about these bills, this bill and other bills like it, and that you carve out nonprofits from this. Thank you so much for your time.
Thank you. Appreciate it. Are there any other persons wishing to testify as opponent on the bill? Not seeing any, then any questions? Senator Clays.
Thank you, Madam Chair. And this is actually directed to Kathy Becker. She brought up the very issue that I have concerns about, although I would probably quibble with stating that ours is more broad. It actually appears more narrow to me. We don't explicitly name ESG or DEI, and we don't use vague terms like non-financial factors. But I think you made a really good point about the fact that this is only if it's against management, but not if a proxy advisor rubber stamps a management proposal without conducting a financial analysis. And I kind of feel like shareholders should know about that too, and that asymmetry does expose us to First Amendment challenge, because it doesn't appear that, or it does appear that we would be endorsing a particular viewpoint. So that said, if we were to fix this, if we were to go both for and against management, would you support this bill? Thank you.
Kathy Becker, do you want to reintroduce yourself and reply, please? She's still on WebEx, but we'll circle back when she gets reconnected. Senator Argabright.
Thank you, Madam Chair. My question is to Matthew, and it's a little bit similar to Senator Clay's. A lot of scenarios in your testimony, and then the opponents brought up broad definitions and more clarity on research and analysis. So along the same maybe lines, just at you, would you support more clarity in your language of this bill?
So I think the bill is...
Please go ahead and reintroduce yourself.
Oh, I'm sorry. Yes, I'm Matthew DeMay. I'm representing Consumers Defense. I think the bill is clear. For example, proxy advisor clearly says means a person who, for compensation, provides a proxy advisory service. And as Ms. Becker said, they don't do that. They don't provide proxy advisory services for compensation. They just are giving recommendations out for free. So that wouldn't apply to them at all. So I think if you look at the actual definitions in the bill, it's clear that this just concerns people who are getting paid for proxy advice and what disclosures they need to make to their clients when they're getting paid for proxy advice. And I think that disclosure is important to clients, whether it's coming from a nonprofit or not, because clients have their own fiduciary duties and considerations. So they need to know whether the information is based on a written financial analysis or if it's not, when they're going against management, which has its own fiduciary duties already. So when there's that contest, when there's a conflict that's set up, then disclosure needs to be made, and it needs to be made to clients.
Thank you. I'm not sure that I'm in the same place you are based on the testimony, including your own, but thank you.
All right, thank you.
Thank you. Do we have Kathy Becker available to answer the question?
Able to hear me now?
Yes, Kathy Becker, Responsible Finance Campaign Director, Green America. Go ahead.
Yes. The question I heard was regarding, I guess, could the question be repeated? Apologies.
Sure, Senator Clays.
Sure. So you made a very good point about the fact that it doesn't appear that we are being viewpoint neutral if we only require the proxy when they're against versus when they're for. And of course, that if we were to fix that, would you then support the bill?
I'd have to talk to my manager about that, but that would make us more likely to. I think we do seek the nonprofit carve out because of the definition or the lack of definition of analysis and research. Anyone could say we're supplying analysis and research just because we put information about shareholder resolutions and what they are on our website. But yes, we do think that it has to be evenly, it needs to be evenly applied regardless of whether the recommendation supports or opposes management. And that's part of why the Texas law was, there was an injunction put on that Texas law.
Thank you. And I'm going to finish with one last question for the proponent. Could you address the symmetry issue that's been raised?
Certainly. Matthew DeMay on behalf of Consumers Defense. So the symmetry issue, the reason it's asymmetrical is because the management of a company, they have fiduciary duties under the law. They have to make decisions that they think are in the best interest of the shareholders. And if they don't, they could be held liable for that. So when a proxy advisor is making a recommendation to vote against management, and management has their own fiduciary duties, you want to know if the proxy advisor's recommendation is coming from their own written financial analysis, whether they're saying, actually, here, we ran the numbers and we don't think that this management recommendation is going to help the company. And so this bill just requires that disclosure in those situations so that you know, as a client, is this recommendation that I'm getting two different recommendations here. What are these recommendations based on? And so when there's that conflict, that's when the bill requires the disclosure.
Thank you. With that, then, we are going to, didn't see other conferees wishing to testify, so we're going to close the hearing on Senate Bill 375 and thank everyone for their attendance today. And committee, I do intend to work some bills tomorrow. We'll start off with working bills rather than conclude with them, so please have any amendments ready to bring. And thanks for the late hour today working. And with that, then, our meeting is adjourned.